Hi students, in this video we're going to look at a piece by Justice Antonin Scalia titled Common Law Courts in a Civil Law System, the Role of the Federal Courts in Interpreting the Constitution. So in this piece, Scalia is going to give his sort of theory of legal interpretation. And if you're sort of wondering a little bit about the title, there are these two kinds of legal systems. There's a common law system and a civil law system. And the U.S. system is kind of like a common law type legal system as opposed to a civil law system. We're not going to talk too much about that, but if you're interested in the distinction between maybe the differences between the United States court system and the court systems in other countries, I would encourage you to look into that more, and I'm happy to talk about that as well. Okay, so before we dive in to this paper, I want to do a little review. So remember, we've been talking about legal positivism, this view that law is connected in an important way with power. And on this view, the existence and authoritativeness or validity of law does not depend on moral facts or principles. You'll remember Austin said that law is the command of a sovereign backed by force. Hart said that law is the union of primary and secondary rules. And that the main sort of idea here behind positivism is that the existence of a law is one thing and its merit or demerit is a different thing altogether. So what is law is one question, whether or not it's a good law is a separate question. Natural law theory is this view, the competing view, sees sort of law as intimately connected with justice, or like in order for law to be authoritative, it needs to be just. So to put it maybe more explicitly or specifically, this view says that the existence and authoritativeness or validity of law does depend on moral facts or principles. Aquinas defines law as nothing else than an ordinance of reason for the promotion of the common good, made by him who has care of the community and promulgated. So that's St. Thomas Aquinas' natural law definition of what a law is. St. Augustine sort of famously says an unjust law is no law at all, and one way of thinking about the natural law theory is this theory that says what it takes to be a law is a rule's got to be just. Alright, so another sort of thing I want to sort of review or look back on is the central philosophical question that we were asking in a case like Riggs versus Palmer. And this is a central philosophical question that also comes up a bit in Church of the Holy Trinity versus U.S. It's this question about what does the law depend on? What's it constrained by? Are we just looking at a literal or a straightforward reading of the statute? Are we looking at the intent of the legislature? Are we looking at sort of maxims or principles of the common law? Or are we looking at sort of moral truths? Do they play a role in what's the law? So this is kind of the question that's on Scalia's mind, on Dworkin's mind, as we look at the debate between Scalia and Dworkin. This is sort of the question. What's constraining the law? What's important here? Now, this is a bit oversimplistic, as we're going to see, but as a sort of quick, rough outline, Scalia is going to say, it's not the intent of the legislature. That is definitely not what the law depends on or is constrained by in any sort of way. The law depends on, for Scalia, something like a literal or straightforward reading of the relevant statutes. Dworkin's going to say, well, I think that the law really depends on the fundamental maxims of the common law in some important way. So there are principles that appear in other court cases, and those constrain how judges should rule in particular cases. And how we should figure out exactly how that works is going to depend on morality in some sort of way or another. So we're going to try and find the maxims that are sort of the best fit for the case that we're looking at. And so we get sort of Dworkin saying some things about these being important. Scalia is going to say, no, it's really something about just the statute itself, how we read it, that sort of thing that's important. All right. So again, now we're going to take a look at Scalia's article here. This is reprinted I think this was originally a lecture or a series of lectures that Scalia gave. It later appears in a book that he wrote, A Matter of Interpretation. And I think whether you're sympathetic to Scalia's view or not, it really is, as far as I know, like one of the most sort of influential theories of any sort of recent Supreme Court justice. So it had a sort of a pretty big effect on the way that people, judges, especially federal judges, Supreme Court justices, rule in the controversial cases. He has this kind of lasting legacy within the sort of conservative side of the court. And as opposed to the sort of liberal side, which is maybe more influenced by something like Dworkin's kind of view or takes Dworkin's kind of view. But even that is kind of unclear. I think I'm not an expert on theories of legal interpretation, but I'm not as familiar with any sort of theory that's as sort of influential as Scalia's. Okay, that's enough about that. So if you've read it already or you're going to read it, one of the central questions that Scalia is going to be interested in this text, in this argument that he's making, is this question about what are judges looking for when they construe a statute? So what are they trying to find? Now, I'm going to sort of give this theory a name. I'm going to call it intentionalism. And this is the view that Scalia doesn't think is right. So he says, according to this other view, which I'm going to call intentionalism, they're looking for the subjective intent of the legislature. So the problem that Scalia sort of raises immediately with this view is that it doesn't sort of square, he says, with some of the few generally accepted concrete rules of statutory construction. So what he's saying is basically, if the intentionalism were true, then we would expect judges to act in these sorts of ways, but they don't, and so that intentionalism view must be wrong. So here are sort of two concrete rules that basically everyone accepts that are in conflict with this intentionalist view. So according to the sort of generally accepted rules, when the text of a statute is clear, then we know what the law says and we're done. So if intentionalism was true, then like even if the text was clear, we would have to say, well, what did the lawmakers intend to say? Or what did they intend to happen when they wrote this? But we don't ask that question. If we think we understand what the text says, then we don't have to sort of look anywhere beyond that. And that suggests that intentionalism is false. Another sort of generally accepted rule is that when the text of a newly enacted statute is ambiguous, the ambiguity is to be resolved by assuming that it's internally consistent and that it's consistent with previously enacted laws. So what we do when there's an ambiguity isn't to go to the intentions of the legislature, but rather we say, well, what would this law, what would it have to mean in order to be consistent both with itself and with other laws? And that seems to speak against intentionalism. So if we want to put these arguments in something like standard form, we get these first two arguments. So first one, premise one, if a judge's objective were to give expression to legislative intent, then the fact that the statute's clear wouldn't end the debate over how to interpret it. But the fact that the statute is clear does end debate over how to interpret the statute. Therefore, a judge's objective is not to give expression to legislative intent. So, we've been learning how to construct and reconstruct arguments, sort of forms. If you look at this, you'll see if A, a judge's objective to give expression to legislative intent, then B, the fact that the statute is clear would not end the debate over how to interpret the statute. But not B, the fact that the statute is clear does end the debate over how to interpret the statute. Therefore, not A, a judge's objective is not to give expression to legislative intent. And so that follows the form modus tollens. It's valid. If you're going to deny Scalia's argument, then you've got to reject one of the premises. Now, I happen to think that this argument's pretty good, and Dworkin, we'll see, is going to agree with Scalia on this kind of point about legislative intent. Scalia's second argument, again, I'm just reconstructing an argument, sort of putting into a form, a valid form, and into standard form, the kind of argument that Scalia is making. So premise one of this argument says, if a judge's objective were to give expression to legislative intent, then judges would not assume that newly enacted statutes are consistent with previously enacted laws. But judges do assume that newly enacted statutes are consistent with previously enacted laws, so the judge's objective must not be to give expression to legislative intent. Again, modus tollens. You'll find that modus tollens is actually a pretty nice form when you're trying to show that a theory is false. So if the theory is true, then it would say B, but B is not true, so the theory must not be true. So that's one thing to keep in mind. Maybe if you're trying to disprove some view or theory, maybe modus tollens is a good form of argument to use because it says if the theory A is true, it has this implication B, but that implication is false, so the theory must be false. Now, Scalia has another sort of third argument that he gives against legislative intent. And this argument sort of emphasizes not that it's sort of inconsistent with what judges do, but this is more of a moral argument. He's saying that there's something unfair, unjust about judges giving expression to legislative intent. And that if it would be unfair for them to give expression to legislative intent, then judges shouldn't do it. Therefore, judges shouldn't do it. Now you might say, well, why is premise one true? So I agree if maybe something is unfair or unjust, then judges shouldn't do that thing. Judges, after all, are supposed to promote justice, right? They're supposed to rule in accordance with justice and fairness. And so if something's unfair, then judges shouldn't do it. But why is giving expression to legislative intent unfair? The answer to this is that if they're trying to give expression to legislative intent, then they're either going to be able to discern what the legislative intent is, or they're not going to be able to do that. So, and he thinks either way, there's going to be something unfair about it. So let's start by assuming that judges are able to discern legislative intent. In that case, then people are ruled by legislative intent, not by the law itself. So if judges know what the legislature intended, then that's really what the law is. It's not the written down thing. And so you might sort of say, well, why write anything down at all if it's just the legislature's intentions that matter? But we sort of think, no, the law is supposed to be the thing governing us, right? That's what we look to figure out what we can and can't do. And so there'd be something problematic about having it be the intentions of the lawmakers that was doing the rule making. Now, if judges are not able to discern legislative intent, then they are going to end up using their own views about what the legislature should have intended to inform their views about what the legislature did intend. So I think this is a nice point. She's saying, in those cases, if we're always looking towards legislative intent, and we have a case where we don't really know what the legislature intended, we're going to sort of substitute our own judgment for what they must have intended or what they would have intended. And when we do that, then we're just, we judges are just making up, what the rules should be. And so we're no longer people really being ruled by the laws, they're being ruled by judges themselves and not the law, and that's bad. And it's bad, either way, as I say here, people aren't ruled by laws. It's bad to be ruled by judges rather than laws for the obvious reason that if you're just, it might seem arbitrary, right? I don't know what judge I'm going to get over my trial, and if they're making the decisions, then whatever they sort of think goes. Well, that's not really a fair way to be tried, and it's definitely not a rule of law in the right sense. All right, so now when talking about this legislative intent view, Scalia talks about the Church of the Holy Trinity versus the U.S. And you'll remember that in that case, the Supreme Court acknowledged that what Holy Trinity did was within the letter of the law. It ruled in favor of the Church because it concluded that Congress hadn't intended to prohibit what the Church did. So they said, yeah, we get that Church of the Holy Trinity hired this guy, enticed them to move into the United States to perform labor or service, and so technically, yeah, they're guilty of doing this. But the Congress would never have intended to prohibit what Holy Trinity did, and so we're going to sort of let them off. And Scalia thinks this is just absolutely the wrong way of going about deciding a case. So he thinks that was the wrong ruling because he doesn't think judges should give expression to the legislative intent. Again, they should look at the law. What does it say? What Church of the Holy Trinity did clearly falls within that, so what they did was wrong. So what are judges looking for? Well, they can construe a statute. It is not the subjective intent of the legislature. What is it instead? Because we look for a sort of objectified intent. It's not the subjective intent, what they wanted in their minds. He says we look for the objective intent, the intent that a reasonable person would gather from the law, placed alongside the remainder of the corpus juris, which I assume is the remainder of the law, remainder of the rules. So this view is called textualism. So Scalia is saying, we're not looking at what people had in their minds in any way. We're looking at what the text says, and that's what the law is. Now, textualism is one version of the view that the law depends on the meaning of the text, but there are others. So there's this one kind of view called like broad or loose constructionism, and what this view says is something like, does the text, when we read it, could it be used to outlaw the thing that the person's doing? In any way, do the words, could they possibly mean that what this person did was wrong? Now, the opposite of that is narrow or strict constructionism. So here we ask, does the law sort of narrowly or strictly construed prohibit the act? And the idea here is that we're not looking at could the law possibly outlaw the thing, but sort of if we're really sort of homing in on what they were trying. Again, that's getting into intent, right? But the sort of a sort of more limited number of things are going to be outlawed on this because we're reading the law a bit more narrowly. So these are both textualist kind of views, and the best way to understand these, right, is in reference to the Smith versus U.S. case, which we're going to look at in a second, right? Scalia thinks that in that case, the majority opinion that said that Smith did use a gun in a drug trafficking crime, that's a kind of broad constructionism, right? They're going to outlaw a bunch of stuff because they're going to give words like use their most general meaning, and insofar as, yep, Smith used it, then he's in trouble. What Scalia says, right, in that case, what he said in that case, is not could it possibly be that he used it, could use correctly describe what Smith did, but rather would it be reasonable to think that Smith used a gun? Would a reasonable person thinking about that law interpret it in such a way that Smith's behavior was wrong? And he thinks the answer is no. So it's this reasonable construction that Scalia thinks his textualist view entails. So some people, Scalia says, call him a strict constructionist, but he says, I'm not that. But I'm also not a loose constructionist or broad constructionist. Rather, I'm a textualist, and that means we need to look at the law, whether or not it would permit the act when reasonably construed. So again, he's drawing sort of a fine line here between this broad construction and this narrow construction. And exactly what counts as a reasonable reading is going to be tricky, and maybe there's something sort of shady going on here. He's sort of trying to pull one over on us by saying, oh, no, I'm sort of in between here. it might be nice to know, well, how do we know what it's reasonable for someone to think? And that's a tricky question, but we don't need to answer it to know that Scalia is a textualist. And what that means is that we're looking at what the law, when reasonably construed, what the law would say. So now we just want to ask, right, do you find these arguments for textualism and against intentionalism persuasive or not? Do you think Scalia's given us good arguments here? And most people think that, yeah, Scalia's arguments are pretty good. Dworkin even agrees with Scalia. So a lot of people reject this intentionalism in favor of a kind of textualism. Now, do they agree with the sort of textualism, the reasonable construal, or do they think maybe we should construe the law more broadly or more narrowly? That's a little bit more controversial, but at least on the intentionalist point, people agree with Scalia. All right, so that is going to, with that, I think we're going to look at the Smith versus U.S. case, mention it briefly. So you'll remember that in that Smith case, the Supreme Court ruled against Smith, not because they thought Congress had intended to prohibit what Smith did, but rather because what Smith did was within the letter of the law. That is, it could truly be said of Smith that he used a gun during and in relation to a drug trafficking crime. So Scalia dissented, you'll remember, because he thinks that a reasonable reading of the statute only prohibits individuals from using firearms as they're ordinarily used, that is, as weapons, during and in relation to drug trafficking crimes. And so his textualism says that Smith is not guilty, whereas he says the sort of broad constructionist view that Sandra Day O'Connor gave, he thinks that view's mistaken. So what are judges looking for when they construe a statute? Sandra Day O'Connor, right, in the majority in that case, said that we should look toward whether the defendant's act violated the law, given some sort of broad or loose reading of the text. So when we're thinking about that, we would ask something like, does a broad or loose reading of the text prohibit the defendant's behavior? And if the answer is yes, then they're guilty. If the answer is no, then they're innocent. But again, Scalia is saying that's not the right thing to look for. What we're looking for is whether the defendant's act violated the law given a reasonable reading of the text. And so something we would ask here is something like, does a reasonable reading of the text prohibit the defendant's behavior? If the answer is yes, then they're guilty. If no, then they're innocent.